for the appellant has referred to the order of the company court at page 12 of the IA approving the merger of the erstwhile company Aditya Birla Chemicals India Limited with the present respondent company Grasim Industries Limited.
Present respondent company, yes, madam.
The fact and that fact has been intimated to the DCIT Central Circle in bracket 4 Mumbai. Stop. As such, this surviving defect is ignored. When counsel for the appellant undertakes to remove defect number 5 in year numbers 19 of 21 within 1 week.
My lord, this defect is in relation to multi-pagination, my lord?
Yes, yes.
My lords, I am praying for ignoring the same, my lords, because multi-pagination is not there, my lords. Those are internal page of a document and running pages by us. So, my lords, I can't change the internal pages, my lords, of a document.
Some pages of annexure are multi-paginated.
My lords.
Oh, what?
My lords, I can't change the internal pages, my lords.
So far, defect number 5 in TA 19 of 21 is concerned, and counsel for the appellant prays for ignoring the same, since the multi-pagination is basically the internal pagination and the continuous pagination of the appeal. Accordingly, it is ignored. Matter be listed under appropriate heading.
Much obliged, my lord.
Commission.
Much obliged. My lords, if it can be listed, my lords, within 2 weeks, so notices can be issued, my lords. I think that is what is pending, my lords.
In the week of 20, in the next week.
Much obliged. Much.
We can issue notice today also.
Up to my lords, whatever my lords is convenient with.
The respondent under registered cover with AD and speed post, for which requisites be filed within 2 weeks.
2 weeks, my lords.
So, additionally, notice be effected on the official email address of the respondent, together with the memo of appeal and its attachment within the same time, and a supplementary affidavit to that effect be filed within 1 week thereafter.
Much obliged, my lords.
After service of notice under appropriate.
Much obliged.
Item is file copy number 24 of 2021. Mr. Prabhat Kumar Sinha for the appellant.
Lordship, in this case, I am praying for 2 weeks time to remove defect. Lordship, defect is very minor. Lordship, actually, file was not come before us. Lordship, so we cannot remove the same. Lordship.
2 weeks more time by way of last indulgence to remove the surviving defects, as pointed out in the previous order also.
All right.
Item 9, file copy number 44 of 2021. Mr. Tejo Mistry for the appellant.
In this case, Lordship, I pray for 3 weeks time, Your Lordship, to remove the defect.
3 weeks time as prayed for. Office to place the file.
Item number 10, file copy number 45 of 2021.
Time may be granted to remove the defect.
For the appellant.
Yes, Mr. Dubey?
2 week time may be granted to remove.
2 weeks time. 2 weeks time to Mr. Mukesh Kumar Dubey and counsel for appellant.
Item 11, file copy number 47 of 2021. Mr. Sudhanshu Kumar Dev for the appellant.
Yes, who appears? Only one defect. CC of decree. 2 weeks, 3 weeks.
WPT number 79 of 2021. Mr. Kumar.
Lordship, I pray for 3 weeks' time to remove the defects. Your Lordship.
3 weeks time as prayed for to Mr. Bharat Kumar and Council for petition.
I'm for state, Your Lordship.
Mr. Ashir Kumar, AC2, AG,
GA2, Your Lordship. GA2.
GA2. Send your appearance slip.
Yes, Your Lordship.
Item 30, WPT number 432 of 2021. Mr. Deepak Kumar Singh or the petitioner.
Yes, my lord. So far defect is concerned, I have already removed the defect on 11/8/2021 by filing the typed copies as demanded by the registry, my lord. And I have also filed an IA.
75. Page 75, this is
Typed copy were demanded, my lord. And on 11/8/21 we have already filed it.
defect number 1, partly. Typed copy of page number 75 may be filed. Defect number 2, fresh copy of page 50 to 67 may be filed. You have already filed.
Yes, my lord. On 11/8/21 we have already filed.
This reporting is of 4th February 22.
Then it must be missing somewhere, my lord. Again we will file within 1 week, my lord. And in the meantime, my lord, I have filed an IA for staying of demand of GST on payment of royalty. My lord, have already passed interim order in similar writ petition on the basis of order passed by Honorable Supreme Court. Annexure 9 is appended with.
We will keep this one in next Wednesday. Meanwhile, you file those typed copies so that defects are reduced.
My lord, they are pressing hard upon, my lord. In the meantime, this similar order may kindly be passed and we will file the typed copy, my lord.
मिस्टर पोद्दार डिफेक्टिव पिटीशन में कोई इंट्रीम ऑर्डर नहीं पास करना चाहिए ना, आप रिमूव कर दीजिए।
ऐसा तो हम लोग किए तो ठीक, हम लोग दोबारा फाइल कर देंगे। ठीक, ओके मिलो।
ये 6 महीने में भी ये ऑफिस को रिपोर्ट नहीं किया है, आपके पास रिसीट है तो शो कर दीजिए ऑफिस में आपकी जूनियर।
ठीक, अगर नहीं भी होगा तो टाइप कॉपी दोबारा देने में भी हमको कोई प्रॉब्लम नहीं पाई। हमारे पास है टाइप कॉपी एक्स्ट्रा कराया हुआ है।
Surviving defects as under which learned counsel for the petitioner undertakes to remove by Friday कर दें?
हाँ,
next week.
Okay, my lord.
By Friday. If the typed copies are supplied, matter will be listed on next Wednesday.
Okay.
I am appearing on behalf of GST.
State Mrs. Ranga Mukherjee.
My lord, I could not connect at serial number 12, my lord.
We have granted you 3 weeks time. Certified
For
copy
removing
of,
defect.
only one certified copy of decree is to be filed.
Obliged, my lord. Obliged.
Yes.
Press planning addition. Item 40, WPT number 5/2021. Mr. Nitin Kumar Prasadi for the of the respondent.
If it may please your lordship.
Yes.
Your lordship, in this matter, we have circulated a mail yesterday praying for an adjournment. We have to file a rejoinder, your lordship, in this matter.
When counsel for the petitioner seeks 1 week or 2 weeks
2 weeks, your lordship.
time to file rejoinder affidavit. An email has also been circulated to that effect yesterday. Accordingly, 2 weeks time is allowed. Matter will be listed thereafter.
Obliged, your lordship.
Here for the
Appropriate. This is Mr. Sarana Mittal for AC2 GA1 for state.
Item 15, WPT number 2980 of 2021. Amrita Sinha for the petitioner. Joseph Kumar Yadav for the respondent.
May I, your lordship? The matter relates to non-filing of Tran 1 due to technical error on the GST portal, and
Ms. Sinha, your client incurred or faced technical glitches every time till 2020 in filing this Tran 1.
Yes, Your Lordship, I have annexed, and thereafter I have annexed the technical glitches paper also that several times he have attempted but he could not. Accordingly, he made a request for that, and that request was also forwarded, but he was not able to open at all the site also. And moreover, at time when he could somehow open the site, his digital signature was not being accepted, and by that signature itself, he was continuously filing his return and all that. I have annexed all those documents. 3-4 attempts has been made. That can be seen, Your Lordship.
So who appeared for the GSTN?
I have served a copy upon Amit Kumar. I have also added him as a party.
Yes, my lords, we see the last order, my lords, had passed an order for adding GSTN as a party, but their name does not appear in the cause list, my lords, and they appear to be the main contesting party.
Mrs. Ranjan, ask him to appear. We will pass over for one case.
Definitely, Your Lordship. I'll just inform him.
Item 16, WPT number 3586 2021, along with item number 70, Mr. Prashant Polo. All the please, Mr. Rahul Amna.
It may please the court, my lord. I am appearing in serial number 16 and 17 on behalf of the petitioner.
Yes, yes.
My lord, in this case, a final assessment order has already been passed and we have filed an appeal before the commissioner appeal, my lord. So the petitioner may be permitted to withdraw the matter without prejudice to its right.
The petitioner had approached this court with the following prayer. Para 1 quote karni. Then counsel for the petitioner submits that during pendency of the petition, the final assessment order under section 143(2).
148, read with section 148, Your Lordship. Reassessment.
Read with section 148 of the Income Tax Act has been passed, against which the petitioner has preferred an appeal. Therefore, she seeks permission. When counsel for the petitioner seeks permission to withdraw this writ petition in order to pursue the appeal. Stop. Then counsel for the respondent, Ms. Amrita Sinha, no objection. Stop. Accordingly, permission is granted. Writ petition is dismissed and withdrawn.
May I just
Like here you have.
May I just submit one thing, Your Lordship?
Yes.
Altogether, 4 writ petitions has been filed. 2 is listed tomorrow, is there on the board today itself. 2 others are also there, so that may be also mentioned and listed accordingly so that it can be withdrawn.
That
extent may be given.
Kindly give the name of those.
My lord, we will be mailing we'll send the mention slips today itself, my lord. Of both.
वो कल लग जाएगा या next Monday को लग जाएगा.
My lord. My lord, a small prayer.
Yes, yes.
Name of Mr. Prashant Pallav may be recorded, my lord.
Give your appearance slip along with the senior.
My lord.
You are Shivani?
Yes, my lord. Shivani Jaluka, my lord.
Okay. Very well. तो 18 से कॉल करो.
For every second. 18 number, item 18, WPT number 1541 of 2019. Mr. Sunil Gabriel for the petitioner, along with item number 19 to 23. Mr. Rajesh Sinha, Mr. D.S. Pati, Mr. Bhavat Kumar Sinha for the.
By the way, item 19 to 22 have been listed only because they are tagged with 18.
Yes, yes, my lord. I had only mentioned 18, my lord. And 18 also only for a very limited purpose, my lord. I filed an IA. IA 978 of 2020.
Straight away coming to the point,
Yes.
please make us understand, at least I can say for myself, what difference does it make if the expression is electronic credit ledger instead of electronic cash ledger?
Yes, my lord, it makes a difference only, my lord, to the limited extent. My lord, there are two separate ledgers which are mentioned under the GST. My lord, the credit ledgers are those where, my lord, whenever I purchase goods and whatever ITC is paid, whatever tax is paid, it goes in the credit ledger. And cash ledger is, my lord, where I deposit the money of my own account, my lord, from my own pocket. So, my lord, I was maintaining the balance in my cash ledger of 1.24 crores. Now, since in the order it has been mentioned as electronic credit ledger, that amount I have already, and my lord, when I make payment of taxes also, then first the credit ledger is debited so that it is utilized, and then rest balance I have to pay by cash, which goes to my cash ledger, and then it is debited. So what is the difficulty which I am facing is that every month when I am filing my return, since I had maintained my balance of 1.24 crores in my cash ledger, which is in my hand. My lord, cash ledger I can keep in my hand a minimum balance. Credit ledger is to be debited every month. So because of which, my lord, the department taking the benefit of the word credit ledger mentioned says that there is no interim order in your favor.
No, but so far as the legal effect of both the expressions is concerned, is the amount deposited in the electronic cash ledger a tax paid already by you, or is it within your custody and it is only the electronic credit ledger amount which is actually a tax paid over which you can avail of the ITC?
Well, this is a misnomer with the department things. Both electronic cash ledger and electronic credit ledger, if I explain it, it's like I am having a bank account in a bank where the money is lying with the bank and the bank has opened two ledger accounts for me. So the cash amount also which is there is paid to the government. It is lying with the government. And
in any case, if we modify the order and make it applicable to electronic cash ledger,
yes,
bereft of the conception or misnomer in the conception,
yes,
the assessee will still have to maintain that balance.
Yes,
in
I am maintaining it even today.
So, what difference does it make to the department?
That no difference, that's the whole point. Department only is catching up the word that you are maintaining balance in cash ledger, whereas you have to maintain balance in credit ledger. This is unnecessary, for which I have to come to your lordships. Para 19 of the writ is clearly mentioned that I am maintaining balance in the cash ledger.
What does the respondent department say? Who is appearing?
Yes, my lord, we have filed a reply to the IA.
Why do you keep yourself off screen, Mr. Pati, when your case is being argued? You just joined the screen.
Perhaps my camera was on, my lord, only I was muted.
No, your
Perhaps
camera off. You just.
But still it is off, my lord.
No. Now it's on. You both
I'm
audible and video also. Yes. So what's your answer, Mr. Pati? What difference
My lord,
does it?
yes. My lord, we have stated page number.
No, you formulate your point.
Yes, formulate, my lord. Twofold ground we have taken, my lord. First was taken, my lord, that this IA comes up after a considerable delay of more than 1 year, and it is an afterthought. Second ground we have said, my lord, that the amount in the electronic cash ledger does not mean that it is lying with the government exchequer. Electronic credit ledger, it is within the control of the department.
If the interim order makes it mandatory for him to maintain that balance, then that remains intact. And so far as the first part is concerned, the difficulty with the SSE could be that despite paying the taxes, the first step to pay the dues is through the ITC, which has been accrued in his favor through the electronic
Yes,
credit
yes,
ledger.
yes, certainly, my lord.
So that he is handicapped every time he has to show that much of balance and unnecessary pay the. So the delay doesn't harm anybody's interest, at least the revenue's interest. The money will have to be kept intact. The whole question is whether the reversal of Senvat credit avail earlier through Tran 1 as per amendment of 2018 or 19 should be permitted or not. Is that so,
Yes,
Mr.
yes,
Yes, yes, my lord. This
yes,
is the main
yes.
question.
And my lord, interim order to save that money in case the petitioner does not succeed.
Accordingly modify it to electronic cash.
My lord, only the stand taken in the affidavit, that is my objection, my lord, that I have taken.
Should we make it electronic credit ledger oblique electronic cash ledger or
Yes, that would do, my lord. That would do. Because Tata Steel, my lord, had not utilized that amount, so it is not hurting them. But we had already utilized it earlier only.
okay? Okay. Third level counsel for the petitioner, Mr. Sumit Girodia and Mr. P.S. Pati for the on the IA number 978 of 2021 seeking modification of the order dated 26 June 2019, since the modification of the last paragraph of the order dated 26 June 2019. Stop. Petitioner contends that unconstitutional content pending disposal of the writ petition, petitioner has been asked to maintain the credit balance in their electronic credit ledger pertaining to education cess and secondary and higher education cess. And if it is done so, no coercive steps shall be taken against him. However, learned counsel for the petitioner contends that though petitioner has been maintaining that credit in the electronic credit ledger, but you are maintaining in both, Mr. Garodia.
No, in cash, my lord, I am maintaining.
He is maintaining in electronic cash ledger pursuant to the interim order. The amount lying in its electronic credit ledger to the same value could not be utilized for availing ITC.
No, my lord, it would not be correct, my lord. My contention is, my lord, that I had pleaded in my writ application itself that I am maintaining my balance in cash ledger because I had already utilized that amount prior to filing of the writ application itself.
The counsel for the petitioner contends that it was pleaded in the writ petition itself that the petitioner is maintaining that amount in its electronic cash ledger since the credit in the electronic credit ledger had already been the ITC available in the electronic credit ledger had already been utilized. Stop. It make no difference